Good afternoon, folks. Thank you for enduring the weather to be here. It's wonderful to be here. Now, when someone gives you an endowed lecture, you're supposed to say it's wonderful to be here. Indeed, you are kind of paid to say it's wonderful to be here. But the reality is, in my case, it is actually wonderful to be here. This is the university where my father-in-law, David Van Tassel, taught in the history department for 4 decades. It is the university where all 4 or 5 of his children, including my wife Emily, received their degrees. It's likewise wonderful to be talking here at the law school, where my sister-in-law Catherine, who is enduring me yet again, will be, received her JD, and where she is currently on the faculty, and where my wife Emily and I have both served as visiting faculty along the way. Indeed, the fondest memories of my visit here were of the students, who were among the most engaged and enthusiastic and supportive I have ever had the privilege to teach. As recently as last semester, I ended up getting an email from one of them, who is now a successful lawyer in California with his own firm, who checked in just with some kind words and to update me on his career. In addition, it's a unique privilege to be delivering a lecture that bears the name of Judge Frank Batiste, whose heroic and unwavering commitment to the rule of law in the teeth of sometimes vicious attacks against him and his rulings illustrate the paramount importance of an independent and impartial judiciary that I'm going to defend here. Now, the title of my lecture is The Twilight of Judicial Independence, a topic that I plan to tackle in 3 parts. First, I'm going to talk a little bit about the structure of judicial independence. Second, I'm going to discuss the history of judicial independence and the problems that have emerged in the latter stages of that history. Problems that have put the future of judicial independence in what I'm characterizing as a kind of twilight that can precede either darkness or dawn. Third, I'm going to turn to how we might address those problems, to the end of improving the prospects for a brighter future for an independent judiciary. Now, I conceptualize the structure of judicial independence in 4 tiers, and this isn't necessarily a conventional conceptualization. At the top is an ancient rule of law paradigm that began with the ancient Greeks, died with the fall of Rome, and was resurrected during the Enlightenment in its most basic form. That paradigm proceeds from the premise that we have fundamental rights that are better protected by self-imposed laws than by autocrats. With respect to the role of the judiciary, it contemplates that courts will impartially uphold and apply the law on a case-by-case basis. To that end, judges must be afforded independence from external interference with their impartial judgment, so they will uphold the law uncorrupted by extra-legal influences. That paradigm acknowledges the need to hold independent judges accountable to the law, but in a limited way, limited largely to the strictures of a judge's conscience and the appellate process, except when corruption or criminal conduct are involved. Now, to this day, this rule of law paradigm and the centrality of judicial independence to that role are repeated as kind of almost a mantra. A couple of examples. Justice Stephen Breyer has written, "Judicial independence revolves around the theme of how to ensure that judges decide according to law rather than according to their own whims or the will of the political branches of government." Similarly, Chief Justice Roberts testified at his confirmation proceedings that judges and justices are servants of the law, not the other way around. Judges are like umpires. Umpires don't make the rules, they apply them. In other words, judges follow the law without allowing their personal views to get in the way. In the second tier, below this paradigm, is Article 3 of the U.S. Constitution, which sought to implement the rule of law paradigm in a rudimentary way. It established a separate judicial branch armed with exclusive authority to exercise the judicial power, and it protected judges from external threats to their independent and impartial judgment by giving them tenure during good behavior and a salary that couldn't be cut. But the text left gaps. Nothing would seem to stop Congress from retaliating against judges for making unpopular rulings by impeaching them, by cutting their budgets, by disestablishing their courts, by changing court size to alter their decision-making majority, to withhold salary increases, or to strip the court's jurisdictional authority. And what if a president undermined court power and autonomy by defying court orders, or using his bully pulpit to delegitimize the courts altogether? To fill these gaps, a third tier of informal constitutional conventions has emerged and evolved over time as a kind of political branch precedent to guide Congress and the President in their relationships with the courts in a manner consistent with the independent judiciary that's conceived in the rule of law paradigm and is implemented by Article 3. These political branch conventions have become entrenched over time, filling gaps and resolving uncertainties in the context of Article 3. Taken together, these conventions have spawned a fourth tier, a general custom of judicial independence that the political branches have, with exceptions, respected. That segues to a discussion of history, which I divide into 4 periods. Judicial Independence 1.0, a period of establishment. Judicial Independence 2.0, the period of evolution. Judicial Independence 3.0, what I would characterize as a period of erosion. And more recently, Judicial Independence 4.0, a period of collapse. Judicial Independence 1.0 was a period of establishment. The new English Americans aspired to establish a separate and independent judiciary. Before the Revolution, they were unhappy with that the colonial judges were dependent on the Crown, and they said so in the Declaration of Independence. After the Revolution, they were unhappy that state judges were dependent on state legislatures. And so at the Constitutional Convention, which may have been a high watermark in the history of judicial independence, they provided judges with tenure and salary protections. These aspirations, however, were compromised by inattention. The founders were so focused on regulating the relationship between Congress and the President that they relegated the third branch to what one historian has called, quote, little more than an honorable mention. The problem of inattention was exacerbated by inexperience. The framers were familiar with threats to judicial tenure and salaries, but they had little experience with other political branch encroachments on the judiciary as a separate department of government. That would change in 1801 with the first transition of political power in American history. The outgoing Federalists passed the so-called Midnight Judges Act, which packed the courts with 16 new judgeships that the incoming Jeffersonian Republicans promptly unpacked before embarking on a campaign to remove other Federalist judges by means of impeachment. For Senator William Giles, who was a cheerleader for the triumphant Jeffersonian Republicans, the lesson of this episode was that the theory of 3 distinct departments of governments and a separate and independent judiciary was, quote, not critically correct, although it is obvious that the framers of our Constitution proceeded on this theory in its formation, close quote. For Giles, the Constitution authorized Congress to have its way with the judiciary and remove Federalist judges, quote, indiscriminately, end quote. The separate and independent judiciary that the framers had aspired to establish in principle was on the brink of obliteration in practice. Now, ironically, the precedent that Giles and his cohort set became precedent to avoid rather than follow. Over the course of the next 150 years during Judicial Independence 2.0, the period of evolution, a series of conventions would emerge, evolve, and entrench to guide Congress and the President. These conventions operated as a kind of precedent against initiatives that undermined the independent judiciary envisioned by the prevailing rule of law paradigm, which the framers had aspired to protect in their Constitution. Now, these conventions would be tested cyclically, following major transitions of political power when new regimes would seek to undermine holdover judges of the old regime, and traditionalists would rise up and defend the court from attack with recourse to established conventions. So, in 1804, after removing Federalist Judge John Pickering by impeachment, a task made easier by the fact that he wasn't just a strident Federalist, he was a strident, alcoholic, insane Federalist, Congress would never again remove a judge for high-handed decision-making, despite more than 30 attempts in the intervening centuries. One of those failed attempts featured Judge Frank Batiste. Judge Batiste was assigned the thankless task of presiding over the Cleveland school desegregation case in the 1970s. He issued orders against recalcitrant school system officials that provoked outrage and multiple resolutions for his impeachment between 1978 and 1981. Let me give you a taste. The congressional sponsor of one such resolution declared, quote, if it were possible to have a vote on that arrogant judge, it would be certain that he would be bodily thrown from office. Until such time as that is possible, impeachment is the only course which can remove this unfit judge from the bench, close quote. By then, however, the convention against impeaching judges for issuing unpopular rulings became so entrenched that each Batiste resolution received a perfunctory referral to the House Judiciary Committee, where it was greeted by the sound of crickets. With respect to the court packing and unpacking, after repeal of the Midnight Judges Act, Congress would never again remove judges by disestablishing their judgeships. Congress would adjust the size of the Supreme Court several times over the years, but never for openly partisan purposes, a convention that thwarted FDR in his attempt to pack the Supreme Court during the New Deal. Similarly, Congress has never exploited its control over the judiciary's budget or salary increases to punish judges or hold them hostage. Note, by the way, that 1/3 of state court administrators report that state legislatures have done just that. So the fact that we haven't seen it in the federal system means something. And after the Midnight Judges Act, Congress never again packed the courts with a mass infusion of judgeships for nothing but partisan gain. Finally, although the judicial confirmation process has always been partisan, the Senate and President adopted procedural conventions like the filibuster, the blue slip, senatorial courtesy, and ABA review of candidate qualifications that encouraged consultation, consensus, and compromise in judicial selection. Such conventions produced a judicial workforce that, with exceptions, enjoyed broad-based support, a workforce that, in the public's mind, could be trusted with its independence. Presidents have followed constitutional conventions too. With the exception of Abraham Lincoln, who broke from a tradition amid the exigencies of the Civil War, no president has openly defied a direct Supreme Court order, a convention that one Cleveland area scholar has described as perhaps the most important convention of all. Sitting presidents have often criticized judicial rulings, but there is a convention against doing so by means of attacking the court's legitimacy or motives. Lincoln once implied that the Supreme Court had usurped power from the people, but he sandwiched that accusation between statements emphasizing his support for a counter-majoritarian court, in other words, for a court that really was indifferent to what was popular at the time, and respect for court rulings. The lone exception in our history is FDR, whose campaign against the Supreme Court included accusations that it had, quote, improperly set itself up as a third house of Congress, for which reason, quote, we must take action to save the Constitution from the court and the court from itself, close quote. The resilience of customary independence embodied in these conventions is attributable to the rule of law paradigm, which guided the formation of the Constitution and the conventions that emerged to fill gaps in the constitutional text consistent with that paradigm. Beginning in the 1920s, however, several developments began to challenge an assumption core to the rule of law paradigm, namely that independent judges can be trusted to impartially uphold the law. So began Judicial Independence 3.0, a period of erosion. The legal realism movement of the 1920s argued that empirical study was essential to understanding the choices judges made because those choices could not be explained with reference to operative law alone. In the 1940s, political scientists began to develop what would later be known as the attitudinal model of judicial decision-making, which posited that the choices Supreme Court justices made are influenced less by the law than by their ideological preferences. The federal judicial appointments process was evolving on a parallel track as the role of nominee ideology in a prospective judge's future decision-making became an increasing focus of Supreme Court confirmation proceedings throughout the 20th century, culminating in the 1987 rejection of nominee Robert Bork on the basis of ideology alone. Nakedly partisan disputes over nominee ideology then percolated down to the circuit and district court confirmation level, where long-standing procedural conventions were repurposed to sandbag nominations of judges deemed activists or extremists. This was happening by Democrats and Republicans alike. It was a game the whole family could play. Beginning in the 1970s, a new politics of judicial elections morphed state Supreme Courts into well-funded campaigns to remove incumbents for making unacceptable decisions. I do not need to tell citizens of Ohio this. Campaigns which proceeded from the premise that independent judges could not be trusted to impartially uphold the law and needed to be controlled at the ballot box. In a series of developments spanning more than a generation, the media became became apostles for the gospel of an ideological judiciary. The traditional media began to report on Supreme Court decisions with reference to the ideological voting blocs of the majority and the dissent. Cable news networks oriented their programming toward ideologically driven infotainment that attacked or defended the ideological tilt of Supreme Court decisions. And citizen journalists, unencumbered by fact-checking norms that regulate the mainstream media, took to the internet and social media to attack judicial decisions that they deemed ideologically unacceptable. Survey data show that the public shares the views animating Judicial Independence 3.0. Significant majorities believe that judges are influenced by their ideologies and that while they say they are following the law, they often act on their personal feelings. Public support for the Supreme Court seemingly remains stable and relatively strong, but there are signs that such support is increasingly contingent. In other words, that liberal and conservative support for the court swings with the court's latest ruling and the appointing president. So that one good example was that after Bush versus Gore, some political scientists reported that the court's legitimacy was stable because it hovered at 55%, but that's because as a consequence of that decision, Republican support went through the roof and Democratic support went through the floor, and it stayed at 55. That is not what you're looking for when it comes to the kind of confidence you want in your courts. These developments show an emerging skepticism of a principle core to the rule of law paradigm, that independent judges hold extra-legal influences at bay and impartially uphold the law. Over the time, the public has simply ceased to believe judges when they say they are following the law and nothing but, and that they are like umpires who simply call balls and strikes. And this, I'll sort of let you digest this for a second. This is from the Citizens United, following the Citizens United case, but the point, you get the point, right? In other words, that we have this paradigm that is now the subject of mockery rather than just sort of simple acceptance. So, what's the implication here? If judges impose their ideological preferences, why should they be independent from political controls when other policymakers are not? Why are they different? They're just like other politicians, and the phrase judges are politicians in robes becomes part of the vocabulary. Which brings us to Judicial Independence 4.0, a period of collapse. In the past 4 years, erosion has yielded to partial collapse in what I'm denominating Judicial Independence 4.0, with a neo-populist wave that has swept more than 40 nations around the world, including the United States. There are several causes contributing to this neo-populist movement. One I would characterize as a kind of democracy fatigue. The percentage of Americans who trust the federal government all or most of the time has declined from 77% at the beginning of the Johnson administration to 17% today, which may help to explain gradual declines in support for the Supreme Court over time. A second contributing cause is the ascendance of anti-elitism. The data show that support for a populist man-of-the-people leader is driven by disdain and distrust for professionals, for the wealthy, for intellectuals, for experts, including scientists, journalists, and career government officials. The implications of these anti-elitist sentiments for highly educated, life-tenured professionals who sit aloft on benches in fancy robes judging the masses seems kind of clear. A third contributing cause is political polarization, an issue that Andra Robertson has discussed in an important article that she published last year. The degree to which average Americans have been polarized along ideological lines has actually remained stable since the 1970s. But our political leaders have become more polarized ideologically, and average Americans have been much more affectively polarized, not along issues, but in their dislike and indeed hatred for the opposing political party, for the party they don't like. Neo-populist leaders have exploited these divisions by exacerbating them and pitting themselves and their cohort against their opponents, whom they demonize. In a forthcoming book, two political scientists show that in highly polarized times such as these, the public is especially receptive to court-curbing measures to control the other side's judges. Voter distrust of experts and disaffection for government as usual correlate with a desire for stronger, more autocratic leaders who can wrest control from elites and reclaim government in the people's name. Once elected, neo-populist leaders across the world have consolidated power by weakening institutional checks on their authority via, among other strategies, stifling dissent within their own political parties, discrediting the media, and of particular importance here, weakening the judiciary. President Trump has ridden a populist wave into power. Aided by a supportive Senate, he has challenged the judiciary's authority in the teeth of long-standing conventions to the contrary, and some of those conventions have begun to yield. Procedural conventions in judicial confirmation proceedings have collapsed. In 2016, Senate Republicans denied Supreme Court nominee Merrick Garland a hearing that he would customarily have received. They repudiated the Blue Slip Convention. They ended the filibuster option in Supreme Court confirmation proceedings 6 years after Senate Democrats did the same for lower court nominees. Finally, President Trump eliminated the American Bar Association's pre-nomination role in vetting judicial candidates, and in the years since, an unprecedented number of judges that the ABA rated unqualified have been nominated and confirmed. Conventions against court packing are likewise under fire. In 2017, Federalist Society Chairman Stephen Calabrese co-authored a memo to both houses of Congress proposing that Congress double the size of the federal appellate judiciary for the explicit purpose of packing the circuit court with conservative judges to neutralize the impact of Obama-era appointments. Democratic leaders, in turn, responded in kind, proposing to pack the U.S. Supreme Court with additional justices if and when the Democrats return to power. For his part, the president has repudiated the Convention Against Delegitimizing Rhetoric. He has responded to court rulings with which he disagreed by dismissing those rulings as, quote, political, and the courts that decided them as disgraceful. He has characterized judges involved as so-called, and Obama judges across an array of tweets and other public statements, culminating in an unprecedented rebuke from Chief Justice Roberts. Finally, the Convention Against Defiance of Court Orders was placed in doubt when the press widely reported that the president was thinking about adding a citizenship question to the 2020 census by executive order in defiance of a recent Supreme Court decision. That threat did not materialize, but it would be naive to think that the prospect of defiance did not remain a viable concern. So, the collapse of independence conventions in Judicial Independence 4.0 was facilitated by protracted erosion of support for the role of judicial independence in the rule of law paradigm during 3.0, when a series of developments challenged the premise that independent judges can be trusted to set extra legal influences aside and impartially uphold the law. One response is to shrug, let judicial independence collapse under its own weight, and welcome a judiciary that is more responsive to partisan and majoritarian pressures. That response makes sense if judicial independence is to blame for its own undoing. In other words, if all it does is liberates judges to disregard the law and basically impose their own personal views, why not? But in my view, the problem does not lie with judicial independence itself, but with how judicial independence has been conceptualized in the rule of law paradigm. In other words, we are past the point as a people where we can fairly look at it and say, yeah, I'm going to honestly believe that judges aren't subject to ideological and other influences. That's something that, the judge looks like their nose is growing when they say that. And I think therein lies the problem. The paradigm reboot I propose begins from the premise that judges are embedded in a well-established legal culture that takes law seriously, beginning in this building and continuing in practice. Hence the name legal culture paradigm. I think we learn how to think like lawyers, which means we take law seriously from the first week of law school. Second, likewise beginning in law school and continuing in practice, future judges are exposed to pervasive legal indeterminacy. If the law was easy, we could do it, via computer program. Law students learn to exploit indeterminacy by arguing both sides of difficult legal questions, divorced from their own policy preferences, to the end of making themselves more effective advocates in an adversarial system of justice. Third, future judges, again beginning as law students, resolve indeterminate legal questions with reference to competing policy arguments. that aid them in deciding which of two comparably plausible arguments is best. When judges are called upon to decide indeterminate legal questions with reference to competing policy concerns, the argument they find most persuasive can be informed by their background, by their education, by their life experience, including their race and gender, by common sense, and by their policy perspective, aided by a strategic sense for the political context in which the issue arose. This is not judging gone rogue. This is judging done right. Oh, I'm depressed. Hold on. There we go. Sorry, I think in my enthusiasm I just knocked it, right? Sorry. I mean, it's not. This is almost as good as it gets. So this is the last slide anyway. Sorry. But the point here is that if you accept this sort of notion, judicial independence remains critical in this legal culture paradigm, which is really just a modest tweak of what we already have. In easy cases, when the law is clear, judicial independence enables judges to uphold and apply the law as they have been acculturated to do throughout their legal careers, without fear or favor clouding their judgment. In tough cases, when the law is indeterminate and judges need to choose between comparably plausible alternative arguments, there is no denying that the choices judges make can affect legal policy. But the policy judges make is case-driven. The outcome turns on the application of facts and law with which the judge is familiar by virtue of the adversarial process, which supplies judges with the specifics needed to make an informed decision. Judicial independence thus positions a judge to give us her best assessment of what applicable facts and law require, unpolluted by external threats and manipulations, an assessment that the judge is uniquely situated and fully acculturated to make. Insofar as this is policymaking, it's fully informed, fact-driven policymaking that is better suited to achieve just results on a case-by-case basis than if the judge was subject to the control of actors who don't know anything about the facts and law and are concerned only with getting the right outcome right to them. The virtue of a legal cultural paradigm is that it defends an independent judiciary in terms that social science verifies and that the public can accept. But by honestly acknowledging the role that extra-legal influences can play in judicial decision-making, the legal culture paradigm has to concede the risk of what I'm calling gratuitous policymaking. In other words, the possibility that judges can abuse their independence by disregarding the law that they are acculturated to follow, whether knowingly or not, and imposing their own policy predilections. Accordingly, the legal culture paradigm proposing envisions a more robust role for judicial accountability relative to the rule of law paradigm to deter this kind of gratuitous policymaking. Now, without disputing the role that Congress and even the President can play in promoting judicial accountability, the additional accountability that this paradigm envisions can be supplied in large part by the courts themselves, by intrajudicial mechanisms that pose no meaningful threat to judicial independence. Let me give you a few examples. Indeed, the judiciary already self-regulates, one, through appellate review of bias-induced errors. Two, through mandamus actions to thwart judicial usurpations of power. Three, through disqualification processes that force the withdrawal of judges whose impartiality is in doubt. Fourth, through procedural rules that structure and limit problematic exercise of judicial discretion. Five, through the Code of Judicial Conduct for U.S. judges, which regulates judicial impartiality and partisan political conduct. Sixth, through the Judicial Conduct and Disability Act, whereby Congress has authorized circuit judicial councils to discipline judges for behavior that's prejudicial to the effective administration of the courts. Seventh, through the oath of office, in which judges swear to act impartially and uphold the U.S. Constitution. That sounds like weak sauce, but if you talk with judges, they take their oath of office seriously. The notion that they would take an oath to uphold the law and then willy-nilly shed that like a ratty sport jacket once they ascend the bench, the evidence is to the contrary. And finally, eighth, informal norms among judges desirous of mutual respect on collegial courts, which discourage openly partisan judging as contrary to the rule of law omission. And I think we can see that on the U.S. Supreme Court, where despite the divide, despite the acrimony, I think the idea of openly partisan judging has been something that we just haven't seen, and I think that's what makes the events of the last couple of days, where you see the dissent effectively accusing the majority of that kind of conduct, is troubling. Now, implementing the proposed legal culture paradigm will help to meet the challenges presented by eroding support for the rule of law paradigm, but it's inadequate to the task of overcoming the threat to the constitutional order posed by Judicial Independence 4.0, this ongoing period of collapse. That is because the legal culture paradigm depends for its success on preserving customary independence by respecting constitutional conventions that are being trashed in the service of dueling campaigns to promote or thwart the neo-populist wave that is sweeping the United States and much of the world in Judicial Independence 4.0. It is unrealistic to hope that a modest reboot of the prevailing paradigm can, by itself, quiet the polarized partisan political fury firing Judicial Independence 4.0, because the judiciary and its independence have become little more than pawns subject to sacrifice in a chess game for the future of American democracy. Throughout American history, there have been cycles of anti-court anger following major transitions of political power. The first two cycles of the 20th century were related. The conservative Supreme Court's substantive due process jurisprudence during the so-called Lochner era thwarted the legislative agenda of angry progressives as they ascended power in the early 20th century. Just as the same jurisprudence, that same Lochner-era jurisprudence, impeded and infuriated the New Dealers a generation later. The end of the New Deal cycle, that latter cycle, was punctuated in part by the most famous footnote in all of Supreme Court history, footnote 4 in the Caroline Products case, where the court signaled its intention to reserve heightened due process scrutiny for cases in which legislation and other state action impinged upon the rights of so-called discrete and insular minorities. Now, the net effect of this pivot was to withdraw the court from protecting the property rights of businesses by second-guessing the wisdom of socioeconomic legislation enacted by progressive legislatures and shifting the focus toward protecting civil rights and civil liberties of political minorities against infringement by majoritarian and often more conservative state interests. As a consequence of that shift, the next three cycles of anti-court sentiment featured angry conservatives taking aim at more liberal federal courts, beginning with the attacks on the Warren Court by state and federal officials in the 1960s, the House Republican campaign against liberal judicial activism following their ascension to power in 1995, and President Trump's ongoing effort to discredit, quote, political, quote, decision-making by so-called Obama judges. In these conservative campaigns against liberal judges, Republicans have made recreating the courts as conservative champions of judicial restraint a centerpiece of their agenda. Democrats, in contrast, have adopted a more passive and defensive approach. They came to regard the federal courts as allies in the cause of protecting the rights liberals held dear, and instead of campaigning aggressively to establish a liberal court per se, they joined moderates in defending the judiciary's independence from cyclical conservative backlash. The net effect has been a manifestation of what some scholars have called asymmetric constitutional hardball, in which conservatives have, with exceptions, tested the limits of independence conventions more aggressively than their liberal counterparts. But Judicial Independence 4.0 may be a game changer. Progressives are awakening to the realization that their conservative adversaries are poised to win a generations-long battle for ideological control of the Supreme Court. Sensing a major jurisprudential regime change, progressives show signs of returning to their roots and launching an offensive in the spirit of their forebears from the progressive and New Deal eras, most notably reflected in their proposals to pack the U.S. Supreme Court. For those of us who regard constitutional conventions as essential to the orderly operation of government and who see merit in customary judicial independence and the conventions that animate it, we must brace for a future that gets worse before it gets better. Pokes to the eye of established conventions by conservative partisans will elicit reciprocal pokes by progressive partisans in lieu of unheeded warnings not to poke at all. This eye for an eye stratagem is very much in the spirit of high-stakes civil litigation, where parties push the limits of applicable rules in scorched earth campaigns to exhaust and intimidate their opponents in pursuit of tactical advantage. In this environment, calls for compromise and detente will almost certainly go unheeded. And so I anticipate that scorched earth tactics will dominate in the short term. Ultimately, however, perpetual hardball is exhausting. Running a government without guiding conventions is chaotic, and therein lies hope. The more insufferable unrestrained hardball gets, the more attractive the alternative of settlement becomes. A key to establishing settlement is to bring the parties together in a quieter and less formal setting to promote candor and discourage posturing for the benefit of external audiences. Beginning in the late 1970s, the Brookings Institution hosted a series of conferences in Williamsburg, Virginia, and elsewhere. These conferences brought representatives from all three branches of government together to discuss court-related issues for the purpose of improving interbranch communication and promoting mutual understanding of challenges confronting the judiciary. And so I look forward to a time when we can convene a series of tri-branch summits in the tradition of the Williamsburg conferences, once adversaries are willing and receptive to meet. These summits could address such topics as the role of an independent and accountable judiciary in American government, the state of constitutional conventions that have served to protect an independent judiciary from encroachment, and the need for procedural conventions in the appointments process to promote a stable system of selection and an independent, accountable judiciary. It is premature to convene these summits until the populist wave has crested and the disputants are prepared to meet and listen. There is, however, room for hope, room for optimism, that the current appeal of the biblical edict, an eye for an eye, will eventually yield to the wisdom of Mahatma Gandhi's warning that an eye for an eye makes the whole world blind. Thank you.
Thank you, Charlie. I'm Jonathan Enton. I'm a faculty member here who's been working over the years with the Batiste Committee. We're delighted to have Charlie here, and Charlie has generously agreed to take some questions. We have at least one handheld mic. Because this program is being webcast, we ask that you wait till you get the mic, and please make sure that your questions are questions. Thanks.
I'm very good at subduing audiences into stunned silence. Yes, sir.
Thank you for a very interesting talk. Could you mention Lincoln during the Civil War and his occasional fraught relations with the federal judiciary?
No.
Could you address the story, perhaps apocryphal, that President Jackson in turn said, allegedly,
Absolutely,
as to Chief Justice Marshall, he's made his decision, now let him enforce it?
Sure. I think there are two. First of all, I think just for that's a pretty well-known anecdote, but the Supreme Court had ruled, I think it was involving a case involving Georgia, as I recall, that in which the issue was that was whether was grossly unpopular. Right. It was in one of the Indian cases, and the word was that he was asked about the decision because there was a groundswell of just rage coming from the state, and what he said was, allegedly was that the Supreme Court has made his decision. Now let the court enforce it. As it turned, there are two qualifiers. One was that the president wasn't under an order himself in that case, and I think that there have been times, and I think you saw this in the civil rights era as well, where foot dragging by presidents and less than fully compliance with court orders imposed against others has been varied and uneven. When it comes to direct orders against the president saying you are ordered to do X or Y, the Lincoln case was the only actual case where we saw this. The statement by Jackson related to an order directed not at him, but it was a question of would he enforce it. The statement that he has made his decision, now let him enforce it, was quoted by essentially a yellow journalist who was sitting in the room with the president at the time. A recent article, and there are others as well, suggest that that isn't what happened at all. In other words, that the language he used instead was that the court has issued a ruling that has emerged on the world stillborn. It was a descriptive point. There was nothing in what he was saying. In other words, he was saying, they made a problematic choice, but there was nothing in there saying, I'm not going to enforce the order. And so it became very popular, I think, because of his populist tone, to be spreading that story, but it appears to be apocryphal, as you implied.
Could you address the Article 1 situation with the immigration judges and say anything hopeful about being able to reverse this at some point?
I think for those who aren't familiar with this situation, the immigration courts are under the authority of the Department of Justice. As you can kind of tell from my talk, I'm a big fan of legal culture because I think it can actually oftentimes salve over all kinds of wounds. I mean, the military courts are an excellent example where technically they don't have much independence, but culturally they do, and they produce some of the best justice in the world. And so historically, immigration courts, although within the scope of the Justice Department, have not been a source of continuous consternation. That has changed now that immigration policies have changed and enormous pressures are being placed on the immigration courts. My only ray of hope for them is that the judges themselves are really pushing back, that there is an ongoing effort to try to create mechanisms that render them more, Article 1E and less directly responsive to the Justice Department. Until that happens, I think we're going to see a bad situation get worse. And I think that part of my message here, I think, is that this neo-populist wave comes from the right, it comes from the left, it has to do with people being fed up with government as usual, and that includes with the customs and traditions we've had. And that also means what's wrong with bullying judges if it gets us the results we want. And I think that it's going to take some time to get that out of our system, because that is ultimately, I think, coming from the right or the left, a catastrophic and unsustainable policy in a democratic republic. So I think for the short term, we're going to have to, I think we're going to have to endure these things, but I'm seeing some really, truly heroic immigration judges pushing back and trying to get out there with more persuasive stories about it.
Hi, I'm Steve Petrus. I'm the director of the Cox International Law Center here at Case. So my question is internationally focused, and it might not be a fair question, okay? But
okay, I'll give you an unfair answer.
All right. You use the term democratic fatigue, you think?
Democracy fatigue. Yeah.
Democracy fatigue, right? Which and then you also said that there are 40 countries in the world that are going through neo-populism.
Yeah.
And what comes to mind are countries like Poland, where there's a direct attack against the judiciary.
Yep.
And I was just hoping you could expand your theory and your discussion today to outside the United States. Like, it seems like there's a what do you call it? What's the virus now? There's a pandemic against judicial independence. Can you comment on that?
No, it's an excellent point. And the data point I got, the 40 plus, is coming from the Tony Blair Institute, which is tracking these things in Europe. And I think that where this, John, you were dealing with Shimon Shatrit really recently. I mean, Shimon Shatrit is an Israeli scholar who has done more than I can't think of anybody else, who is looking at international standards for judicial independence and is trying to gather scholars together on an ongoing basis to deal with this problem. As you can well imagine, right, cultures are different from jurisdiction to jurisdiction, and so I get ants in my pants when I try to sort of do a one-size-fits-all thing. When we try to, we meaning the U.S., try to export American brand judicial independence to Latin America and to Eastern Europe, it made me feel vaguely creepy because it sort of proceeded on the assumption that we know best. And so one size doesn't fit all. But, I mean, in defense of your point, I think it is absolutely true that we've got this problem with common features around the globe, and we've got people like Shatreat trying to work toward developing uniform international standards of judicial independence that might be helpful. Beyond that, that's where my competence ends, and I'm yours continues, and so that's where I'm going to shut up and not sit down because I can't. But yeah.
Fair enough. Could you go back to your descriptions of the rule of law paradigm as contrasted to the culture of law or legal culture
right. Hold on.
paradigm?
Yeah.
And maybe in particular highlight the distinctions that would explain why the former has been susceptible of erosion and now collapse, as you put it, that wouldn't also be true of the latter.
Okay, I mean, thank you for that. I mean, I think one of the problems in trying to compress things down to 35 minutes is that I do kind of a half-assed job with it. I think that when it comes right down to it, I guess the point I'm making is that what judges say is that we follow the law and nothing else. We are, and if you look at the public dialogue, you will never get any hint to suggest that they are influenced by ideology, by race, by gender, by strategic considerations. And over the course of time, the public has never believed that outright. For thousands of years, the public understands that judges are subject to other influences. But they've been willing to accept what Keith Bybee has called an acceptable hypocrisy. The problem, I think, is beginning with the social science and legal realism movement. We're gradually seeing it becoming an unacceptable hypocrisy. In other words, that we're now seeing more and more pushback against judges, and we're seeing in the various developments I'm describing, like the new wave in federal judicial appointments, in state judicial elections, and in other contexts where we're basically saying enough of this, you aren't subject to extra legal influences, we're just going to assume that you are, and you're lying when you say otherwise. And I think that if we perpetuate that down the road, my point is that the public isn't buying it anymore. We're not scoring any points. We're going to lose the argument in the long term if we continue this sort of naive sort of argument. And, I gave this lecture relating to this to the Third Circuit Judicial Conference, and the person who popped up in front of me at the end was Justice Breyer, who basically said, you're absolutely right, but we're fearful of how to basically say we do something other than that. And, in other words, and so it's cheap for me to be here as a tenured academic to say, well, what you got to do is acknowledge reality, that you're subject to these extra legal influences, that yes, at the margins, ideology matters. Yeah, we have data showing that in race discrimination cases, that white judges dismiss them at a higher rate than black judges. I mean, that this is something that's concerning. We need to be mindful of it, and that in reality, if we accept that as long as judges are acculturated to do their best to follow the law, and at the margins they are subject to these influences, that's something we can actually and ultimately get behind. But the response to that is, well, do you actually mean that the next Supreme Court nominee is going to show up before the Senate and say, yeah, I'm not all about following the law, I'm just mostly about following the law? I mean, take out the shotgun, right? But my point is, no, you begin at the grassroots level. Judges talk to juries, judges talk to classrooms of children coming through. Children go to judges. And judges talk at local, civic organizations. We're beginning the conversation about the art of judging, rather than as if judging is a mathematical formula, rather than if judge is a science. It's an art. When you sentence a criminal offender, what do you think about? You're exercising discretion and judgment. When you're not enslaved by sentencing guidelines, you're exercising discretion and judgment. There is, something to be proud of in that. And I think that over the course of a generation, if we start recognizing that what judges do is part art as well as part science, and that judges do exercise judgment and discretion in ways that brings these, common sense, background, education, ideology, and race and gender to bear. There is nothing wrong with that, but it's going to be it's a long, slow process. I mean, that's a filibuster, but did it kind of sort of answer your question? Yeah.
You said, I think, that there have been a great number of judicial nominees recently deemed unqualified by the ABA, and I think you said they were confirmed anyway, or something like that. I wasn't aware of that. How many of those instances have there been, and
Sure.
What do you think of that?
What we have is the data I've seen began in 1989 with Bush 1. And in Bush 1 and in Clinton and in Bush 2, the ABA gave unqualified ratings to really a handful of judges in each administration, 3, 4, 5. 1 or 2 of them were confirmed, most of them were not. During the Obama administration, Obama was basically committed to not nominating any judges that the ABA deemed unqualified, and so the ABA got first crack at the list of nominees, and so in his 8 years, no judge that the ABA deemed flat out unqualified was nominated. So as of, between 1989 and the last 3 years, there were a total of, I'm trying to work backward and do the math, 12 judges across 20 some odd years, and only 1 or 2 of them had been confirmed. Under President Trump, 9 judges have been nominated who are disqualified in 3 years, of whom 7 were confirmed, the first 3 ever confirmed at the circuit court level, and the first 2 who were ever confirmed in the face of a unanimous unqualified rating from the ABA. So we're looking at a much higher number, raw number, in 3 years than we saw in the entirety of the Clinton administration or in the entirety of the George W. Bush administration, compressed in 3 years. Now, I think just the pushback is that there is some argument that the ABA has a liberal-leaning bias in its confirmation. And there is some support for that in the extent to which it rates candidates very qualified. There isn't as much support for the argument that they are rating legitimately qualified people unqualified. And so I think it's a little harder to make the case that it's simply that the ABA has been replaced by the Federalist Society in the pre-nomination role, and I think the campaign to change kind of I think there's concern about the so-called Obama-era judges, and there's a premium placed on ideology and youth that is occasionally been eclipsing traditional qualifications.
First of all, thank you for coming and giving this talk. Sure. It seems increasingly common that in legislative hearings for judicial nominees, the questions are either strictly political or even going so far as to ask whether or not they would overturn specific decisions. Do you believe that any guidelines or regulations should be introduced, or is it simply up to the judges to avoid answering these questions?
Yeah, that's a good question. I think that it's there's kind of an evolution to it that really there was a really quiet dance that went on in the first part of the 20th century. For example, during the confirmation proceedings of Louis Brandeis, there were just sort of questions about, I wonder if he's a dangerous radical, which is code for he's going to be issuing leftward-leaning decisions that we care about. But there really wasn't a full frontal sort of assault on nominees until the Bork confirmation. There was a little bit of it when President Nixon was appointing Hainsworth and Carswell and calling them strict constructionists, and that was kind of red meat that was baiting the Democrats at the time, but there wasn't the same kind of dialogue that we first saw in the Robert Bork proceedings. And part of that was that Robert Bork just loved to talk about the way his ideology would influence his thinking. And so, in some ways, he was his own worst enemy. And to some extent, I mean, this is kind of a fun little fact story about the Bork nomination. In my former life, when I was a professor at Widener, I team taught a course with Joe Biden back in 1991, and he was reporting that he was called in to visit with President Reagan and given a short list of nominees to to review, and that he was asked who on this short list is acceptable or unacceptable. On a list of 10 names, he said there are really 8 that are fine and 2 that are not. One of those 2 is Robert Bork, and the president said fine, and the next day nominated Robert Bork. And I think that that's kind of a realpolitik dimension to this process that influence things. I'm not meaning to sort of digress altogether. And in answering your question, I think that first of all, judges are under a duty not to comment on pending or impending cases and their outcomes and how they would vote on them. That's in the Code of Conduct for U.S. judges, and most of these Supreme Court nominees are sitting judges, and those that aren't are still trying to abide by that. So in no event can you do that. On the other hand, they're morphing that into, I refuse to answer any questions about philosophy, I refuse to answer any questions about the rightness of, for heaven's sake, Marbury versus Madison, or Brown versus Board of Education, as a way to basically say, I'm going to basically go in the duck and cover mode under my podium and hope that you'll vote for me anyway. And so I think that really it's a response to the Bork rejection that nominees have learned that the best way to survive the process is by not responding. And so we can provide all the guidelines we want, but until there is a motivation for them to be more forthcoming, I just don't see it happening.
Yes, what do you feel the next crisis will be? Will it be with a potential political change, a court-packing situation or threat, or do you think it will be what will be the turning point?
My biggest worry is open defiance of a court order. That what we saw in the census case was a decision coming down saying thou shalt not include a citizenship question on the census, and the president referred to it as a ridiculous ruling, and then was reported to be considering ways to include it on the census anyway. One interpretation was all he was trying to do was find a way to do that consistent with the Supreme Court's decision, which would not be defiance. But the fact that the lawyers litigating the case sought to withdraw from the case, which normally happens only when their client is basically planning to do something that they cannot represent him if he does, I think it's fair to say there was concern that the president was going to defy. And I think President Trump has a history of thinking about things going one way and then thinking about them some more and going another. And I think if we have defiance, we could have a legitimate constitutional crisis on our hands, by which I mean a situation in which we don't have a constitution with a mechanism that is made to remedy a situation where a president is subject to an order saying, you must do X, and he says no. And I think that would be the most likely it. I think with packing the courts, I think that's unlikely. I think that's more likely to be the kind of stuff that the kind of the neo-populists on the left are trying to do, to say I'm not going to take this sitting down. I think the likelihood that will actually materialize is fairly low. But yeah.
Yes. Sure. First of all, thank you very much. And time evaporates. I want to honor Judge Batiste's memory in a number of ways. First of all, by quoting Mary Ann Glendon, learned hand professor of law at Harvard, and how she said, what animates the law? Oh, critical, ongoing, reasoned reflection. Critical means asking questions. Mm-hmm. I repeat, core, critical, ongoing, reasoned reflections. And to honor the judge again, apart from defining carefully, reflecting, critical reflection, asking questions, and I'm here sitting, listening to you gratefully with other fellow former clerks of Judge Batiste. Thank you. At the same time, a new book, Conversations with Ruth Bader Ginsburg, RBG. Who puts it together? It's everywhere now. It's short. I've given it as a present. Professor Jeff Epstein mm-hmm. from George Washington University. Friendship. In that book, RBG's friendship with Antonin Scalia is eloquent. And reading that book reminded me of Judge Batiste's really treasuring what friendship means. When does an acquaintance become a friendship? Critical, ongoing, recent reflection. And Mary Ann Glendon bringing in the definition by Raymond Aron, who passed away in 1983, French philosopher, not letting one's values prejudge one's conclusions, nor dominate the process of analysis. That's what a judge, an independent, impartial judge does. And so, the independence of the judiciary, and that first paradigm you cite, the rule of law, and you say it has evolved, and now we talk about a new paradigm, legal education, legal culture. In many ways, they are linked. They are truly linked. And I think differentiating the question asked, what's the difference? How do you define that first paradigm? And then you go into the second paradigm. It's like splitting hairs sometimes. When you think of Mary Ann Glendon, and you think of RBG, and you think of Antonin Scalia, and RBG, Ruth Bader Ginsburg, would be the first to explain how much all they had in common despite their jurisprudential differences. Nonetheless, public servants, nonetheless, love of law, nonetheless, friendship, all intertwined. Judicial independence, I'm hopeful, will prevail.
Yeah, I mean, I think that was wonderful. I think the only point that I will make in response is that if you talk to judges like Anton Scalia, if you talk to judges like Ruth Bader Ginsburg, they will privately tell you that, you know, judging is very complicated, that what we say for public consumption, that it's not. In other words, we just follow the law. Isn't the way it works. And that the survival of our judiciary depends on the collegial relationships that we have. And if you look at the Wisconsin Supreme Court, which has gone down the drain in the last 10 years, it is not because of ideological divides. It's because of collapse of collegiality norms. And my worry for the U.S. Supreme Court is that in this latest dissent, we're seeing some of that real anger that we just haven't seen. As you say, Ginsburg and Scalia were fast friends despite throwing stuff at each other for opinions for 20